Hi, this is Heather with Bootleg Legal. Today we're going to talk about protecting your intellectual property. For many companies today, in fact, probably a large majority of them, their intellectual property is their most valuable asset. That can be in the form of patents, copyrights, trademarks, or trade secrets. Some companies, you might be shocked to find out that their most valuable asset is their trademark. Coca-Cola, for instance. Coca-Cola didn't actually make Coke or sell it. They would, and I know that this model, I think with them is changing, but they would license the right to use their trademark to distributors and then give them the formula. And then the distributors would be the one actually selling the Coke products. And the company known as Coke made its money off of that, basically off of letting people use its trademark. So, and the same thing can be said for all the tech companies, right? The copyrights that are held in all of their apps and websites is their most valuable asset. So protecting your intellectual property, especially in the day when corporate espionage, so to speak, is fairly easy. So protecting your intellectual property is of preeminent importance right now. So what are these things? And I'm going to read some of these just to make sure that I say them correctly and completely and I don't leave anything out. So a trademark is a symbol, word, or words legally registered or established by use as representing a company or a product. A patent is a government authority or license conferring a right or title for a set period, the sole right to exclude others from making, using, or selling an invention. But not every invention can be patented. A copyright is the exclusive legal right given to an originator or assignee to print, publish, perform, film, record, literary, artistic, or musical material, and to authorize others to do the same. And a trade secret is a formula, practice, process, design, instrument, pattern, commercial method, or compilation of information not generally known or reasonably ascertainable by others, by which a business can obtain economic advantage over the competitors or customers. Okay, so that's a lot of legalese, right? So I'm going to break down in sort of layman's terms what each of these is. A trademark is your logo or the word that you do business under. It's the word that your customers and clients associate with you and your brand. It's very important to protect your trademark, because if you don't and somebody else uses one that's very similar, especially in your industry, it can be very misleading. It can damage your brand if they don't do a good job, and it can just steal your customers if they do a good job, right? So you want to, with regard to trademarks, the best things that you can do are to register your trademarks. It's fairly inexpensive. You can probably do it yourself, although there are many lawyers willing to help you if that's something you'd like to get off of your plate. Registering your trademark isn't necessary. You actually own a trademark the moment you start using that trademark in commerce. However, you're going to own it only as to your geographic location, and you're going to own it only into the classes you're actually using it. Like, if you're a law firm, it's a legal services business, right? If you register it federally, you're presumed to have the federal trademark nationwide. And in addition, you get to pick which classes that you apply for your trademark in. It does cost a little extra per class. But then when somebody infringes on your trademark, you get more damages because there's a presumption that they should have checked, right? They should have checked the federal registry to see if somebody was using that before they started using it. So it's worth its weight in gold to protect your trademark. However, if you are really lean and you have no funding for anything but the absolute bare necessities of running a business, then don't. Use it in commerce, put it on your website, put it everywhere. And from the time that you can demonstrate you were using it, you do own that trademark, registration or no. All right, a patent, I'm not going to get too much into because you need a lawyer. I mean, the patent bar is a separate bar of lawyers. They usually have engineering backgrounds. I think they might have to have engineering backgrounds, but they absolutely have to pass a separate bar exam in order to be a patent attorney. And so if you're going to be filing a patent, and you don't have both a legal and an engineering background, I would highly suggest using an attorney. Copyright. Copyright's like trademark. If you wrote it, if you created it, if you made it, you own it. Registering it, however, just like with trademarks, gives you that additional protection because it puts everybody else on notice that you are claiming ownership of this. Makes it searchable, makes it easy for people to make sure, let's say you were trying to license your material, be it a song or writing, or you're trying to get something published through a publishing house, and you own the copyright to it. It makes it easier for them to verify that you indeed own that. And again, it creates higher damages awards if somebody does infringe upon it and steal it. Trade secrets are the ones I really want to talk about because most people don't understand what a trade secret is or how valuable that they are. Your trade secret is your secret sauce, okay? This is the thing that makes you different in a nutshell. It's the thing that if your competitors knew it or had this information, that you would not be able to compete with them. Okay, so it might be the way you handle client intake. It may be your marketing procedure. It might be, in the case of representing Halo Top, it was their formulas, right? Their ice cream. They were making the best tasting healthy ice cream on the market. There were other healthy ice creams on the market prior to them, but the reason that they came in and took the industry by storm was because their recipes were better at the end of the day. So if those fell into the hands of somebody else, that could be it for them, right? Trade secrets can cover a very broad category of information, but the requirements for something to actually be a trademark are that it is not known, right? If it's something you're putting on your website or something you're telling your customers, it's not a trade secret because it's not a secret. It has to be a secret. So it has to be something that, number one, is a secret and that you keep secret. And then number two, it has to give your company independent economic value, which just means it's not, just something you do that people like or appreciate, but it's something that actually allows you to make more money than your competitors. Protecting trade secrets is key. The most likely method in which somebody's going to infringe on your trade secrets are when your employees leave you, right? Because they know how you operate. They know your secret sauce. They know the things that you did. Maybe it's your pricing schedule. Maybe it's the way you find leads to reach out to. Maybe it's the way you deliver the product or service that you deliver, right? It could be any of these things. And they know it. And, it would be very tempting for them, especially if the termination of their employment wasn't on good terms or wasn't on their terms. It'd be very easy for them to go to a competitor or even start a competing business. I had one case way back in the day where my client had started a business, grown it pretty large. I think they were, 50 to 100 employees. And they at one point decided to bring in some partners, and these partners had never worked in the industry before, not for 1 second. And they came in and they learned the business for 2 or 3 years. And then they literally walked out with not just their phones, headsets, and employees, but every one of their trade secrets, right? So we had to sue them. Of course, we would have won, but they settled because it was a slam dunk case. You can't steal somebody's business secrets. So the best things that you can do to protect your trade secrets and protect all of your intellectual property. Number one, use NDAs. What's an NDA? It's a non-disclosure agreement. But NDAs aren't like ordinary confidentiality agreements or confidentiality provisions. An NDA is like a stopgap measure. You use it before you have a formal agreement. So when you're thinking about doing business with each other, but in order for the parties to decide whether to go into business together, they need to know more about each other, then you would use an NDA and say, look, I'm going to give you this information, but only towards the end of working together. If it's not something that we're going to end up doing, all this information, obviously you're going to need to destroy it and keep it confidential, blah, blah, blah. This, like if somebody's thinking about investing in your company, if they're thinking about buying your company, if you're thinking about entering into a joint venture, basically anybody that you need to share confidential information with prior to actually entering into a formal agreement with. Those are the instances when you want to use NDAs, and they should be short and sweet. They can be unilateral, meaning one-sided if only one party is sharing information. They can be mutual if both parties are sharing information. They are not, a lot of people think that they are general confidentiality agreements. And they're not really contemplated to be that. They're usually short, like 3 pages, and they don't incorporate all of the other terms that you're going to need in an agreement. So they're very much a temporary measure. They're designed to be a temporary measure. So what do you use for more formal agreements, like with your employees, for instance? Little secret about employment agreements that I will go into in the employment lesson is there's really only one thing that the company gets out of an employment agreement, or one really valuable thing, and that is protection of intellectual property. You give the employee, oh, here's an agreement that I give you all of I tell you what you're going to get, I tell you what you're going to do, I tell you what your title is, all of those pieces of information. If it's an executive agreement, it's going to be more involved. But generally, I'm just giving you all of that in exchange for you basically giving me intellectual property protection. And this is a confidentiality clause. This is an invention assignment agreement. So basically, they're saying, I agree that anything I learn here, I'm going to keep confidential. And anything I make here, I'm going to make sure you own it, right? That's what these agreements do. They can be baked into an employment agreement. They can be a standalone agreement called a confidentiality and invention assignment agreement. Doesn't matter. As long as the terms are there, the terms are there. So you want to use this with anybody that is working for you, whether or not as an employee or an independent contractor. You want to have them sign a CIAA or an employment agreement with the CIA terms. Okay. One note real quick, because I don't think I went into it. You can have valuable confidential information that does not rise to the level of being a trade secret, right? Maybe it's not sufficiently secret, or maybe it doesn't drive enough independent economic value, but it's still something that's valuable to you. So you should be protecting at all of these steps, whether at the NDA step or whether at the CIAA step. You want to be differentiating between confidentiality and trade secrets. And the reason is because there are some states that are hesitant to enforce indefinite protections of confidential information. There's a general rule in the law that you shouldn't have contracts that have perpetual terms. And so when you say, every piece of information that I share with you, I'm going to deem confidential and you have to protect it forever, there are actually courts that won't enforce that, and then you're kind of screwed. And so what you should say is, because now business is done across state lines. Before, you would just tailor it to whichever state. Are you in a state that will enforce indefinite protections? Cool. If not, don't. But now business is happening everywhere. So you need to have a form that works everywhere. And so what I do, and what I think is best practices right now, is to have indefinite protection of trade secrets, which you phrase like, the trade secret shall be protected for as long as it's a trade secret. But confidential information, put a timeline on there, 3 years, 5 years, whatever. Usually confidential information that doesn't rise to the level of being a trade secret is not even something that you're going to care about 3 to 5 years from now, okay? Unless it becomes a trade secret, it's protected by being a trade secret. Okay. Label proprietary business confidential. Put that stamp on there anytime confidential information is going anywhere. Collect intellectual property from departing workers if they have it. This is very hard in an electronic age. It may be on their personal computer. They may have confidential information on their phones just via doing it may not be malicious. It's just they're doing work from their phones or their home computers. I would work with an attorney or an intellectual property expert of some other sort, or just figure out methods yourself to make sure that your employees can't take your valuable confidential information with them when they go. You're going to want to utilize security methods to make sure that no one is stealing your confidential information or trade secrets. This one is more true for larger companies. So as you grow, or if you've got extraordinarily valuable intellectual property that someone might actually have an interest in stealing. Most people have really weak passwords. They often write their passwords on like Post-it notes. Their phone is available all the time. They're having confidential calls like in public, where any bystander might hear the company name and it might trigger something. So have systems in place to prevent these things. Really do the work, especially if you have valuable intellectual property that you can identify. Something that if somebody else found out, you would be in a very bad way. If that describes you, take the steps, do the deep dive, figure out who has access, who should have access, how you can protect it despite the fact that they have this access, and put policies in place and actually follow them. It may sound like a lot of work, but if you are a Halo top with those killer recipes, one slip up could really undermine your business, especially at the growth phase when it's really taking off. You have to pursue infringement of your rights. If someone uses your copyrighted information or your trademark or your trade secrets or your patent, and you don't pursue them, you could be deemed to have waived your right to later pursue them, because part of the requirement for something to be intellectual property is that you treat it that way and you pursue violations. So if you sit back the first several times you hear a violation and then try to go after it the fifth or sixth time, you could find yourself in a problematic position with the courts who are saying, this isn't a trade secret anymore, or this isn't even a trademark anymore. You've let everybody use it without licenses. So it's not yours. And then just like that, you've lost it. It has happened. And yeah, that's about it for protecting your intellectual property. I went a little longer than I expected, but hopefully you got some useful information. When in doubt, please speak to a lawyer. If you are a lean startup, the best things that you could do, the cheapest things you can do on this front are to use NDAs and always use CIAs, confidentiality and invention assignment agreements. Use them all the time. And label your confidential info confidential. Those are the cheapest, easiest, quick and dirty things anybody could do. And to be completely honest, you can probably find an NDA on a website that's good enough on just Googling it. CIAAs, you might want to talk to a lawyer, but you might be able to find one that's okay, a little less confident there, but you could probably DIY your own NDAs, especially with the information I gave you. Thank you.